Welcome to G Fun Facts Online. Today we're diving into one of the biggest power struggles in American history, a battle that's been raging for over 200 years. It's not between political parties or rival nations. It's a heavyweight match between two of the most powerful institutions on Earth, the President of the United States and the Supreme Court. This isn't just a legal drama. It's a constant negotiation that defines the limits of what a president can actually do. The U.S. Constitution is brilliant, but it's also brief, and it left a lot of the details about presidential power deliberately vague. It's the Supreme Court's job to fill in those blanks, to draw the lines, and to answer the question, how much power is too much? This ongoing tension is built into the very fabric of American government through two key ideas: separation of powers and checks and balances. The idea, borrowed from the philosopher Montesquieu, was simple but revolutionary: divide power to prevent tyranny. Congress makes laws, the president enforces them, and the judiciary interprets them. To make sure no one branch gets too powerful, they each have checks on the others. The president can veto a law, but Congress can override it. And the Supreme Court has the ultimate check, the power to look at an action by the president or a law from Congress and declare it unconstitutional. This power, known as judicial review, is the main weapon in the court's arsenal, and the story of how they got it is where our journey begins. It all starts with a political soap opera in the year 1800. President John Adams, a Federalist, had just lost a bitter election to his rival, Thomas Jefferson. In the final, frantic days of his administration, Adams and his party decided to stack the judiciary with loyal Federalists, creating new judge positions and rushing to fill them. These were nicknamed the Midnight Judges. One of these would-be judges was a man named William Marbury. His official commission was signed and sealed, but in the chaos of the presidential transition, it was never delivered. When Thomas Jefferson took office, he was furious. He saw the appointments as a cheap trick and ordered his new Secretary of State, James Madison, not to deliver Marbury's commission. So Marbury sued. He went directly to the Supreme Court and asked for a writ of mandamus. Basically, a court order forcing Madison to do his job and hand over the paperwork. This put the new Chief Justice, John Marshall, in an impossible position. If he ordered Madison to deliver the commission, the Jefferson administration would almost certainly ignore him, making the Supreme Court look weak and powerless. If he refused, he'd look like he was caving to political pressure. Marshall's solution was nothing short of a political and legal masterstroke. In the 1803 case of Marbury versus Madison, he wrote the court's unanimous opinion. First, he said that yes, Marbury was absolutely entitled to his commission. But then, he pivoted. He asked a different question. Did the Supreme Court have the authority to issue the order in the first place? Marbury had based his case on a part of a law called the Judiciary Act of 1789. Marshall declared that specific part of the law was unconstitutional. He argued that the Constitution itself carefully lists the types of cases the Supreme Court can hear directly, and Congress didn't have the power to add to that list. In doing this, Marshall established the monumental principle of judicial review. He famously wrote, "It is emphatically the province and duty of the judicial department to say what the law is." While Jefferson and Madison won the battle, Marbury never got his commission. Marshall and the Supreme Court won the war. They had just given themselves the power to strike down acts of Congress and the president. This case laid the foundation for every future clash between the court and the executive branch. With this new power established, the court would eventually face off against presidents on the most significant source of their power, their role as commander-in-chief. The Constitution gives the president this title, but what does it really mean, especially in times of war or national emergency? This question came to a head in 1952 during the Korean War, in a case called Youngstown Sheet Tube Co versus Sawyer, better known as the steel seizure case. The nation's steel workers were threatening to go on strike. President Harry Truman worried that a shutdown of the steel mills would cripple the war effort. So he did something drastic. He issued an executive order to seize the steel mills and have the government run them. Truman argued that as commander-in-chief, He had the inherent power to do whatever was necessary to protect the country in an emergency. The steel companies sued, and the case shot up to the Supreme Court. In a stunning 6-3 decision, the court ruled against the president. Justice Hugo Black, writing for the majority, said that a president's power must stem either from an act of Congress or from the Constitution itself. He found no such power. In fact, Congress had previously considered giving presidents the power to seize industries during strikes, and had explicitly rejected it. Truman had overstepped his authority. But the most influential part of the ruling came from Justice Robert Jackson's concurring opinion. He laid out a simple, three-part framework for judging presidential power that is still used today. Think of it like a traffic light. Category 1 is the green light. When the president acts with the approval of Congress, his power is at its maximum. Category 2 is the yellow light. When Congress hasn't said anything one way or the other, the president operates in a zone of twilight, relying on his own independent powers. The outcome here is uncertain. Category 3 is the red light. When the president acts against the expressed will of Congress, his power is at its lowest ebb. His actions are likely unconstitutional. Jackson concluded Truman's steel seizure was firmly in that third, red light category. The Youngstown decision sent a clear message. Even a wartime president is not a king. His power has limits set by the Constitution and by Congress. This dynamic continues today. The court has generally been hesitant to get involved in whether a president can start a military conflict, often calling it a political question for the president and Congress to sort out. But in the post-9/11 era, in cases involving detainees at Guantanamo Bay, the court has pushed back against the broadest claims of executive power, reinforcing the idea that even in the fight against terrorism, the president is still bound by the rule of law. Beyond war powers, presidents have another controversial tool they claim is essential for the job: executive privilege. This is the idea that a president can keep information secret from Congress, the courts, and the public to protect national security or ensure he gets candid advice from his staff. It's not written in the Constitution, but presidents have claimed it since George Washington. The ultimate test of this power came with the Watergate scandal and United States versus Nixon in 1974. As investigators closed in on the cover-up of a break-in at the Democratic National Committee headquarters, they discovered that President Richard Nixon had a secret taping system in the Oval Office. The special prosecutor investigating the scandal subpoenaed those tapes, believing they held evidence of a criminal conspiracy. Nixon refused. He claimed an absolute executive privilege, arguing that the separation of powers meant the courts simply couldn't force a president to turn over confidential communications. It was a direct constitutional showdown. The Supreme Court's decision was unanimous and historic. They ruled against Nixon. Chief Justice Warren Burger acknowledged that a limited privilege for sensitive military or diplomatic secrets likely exists. But, he wrote, a general claim of privilege cannot be used to hide evidence in a criminal investigation. To allow that would undermine the entire judicial system. The court declared that the fundamental demands of due process of law outweighed the president's claim. No one, not even the President of the United States, is above the law. The court ordered Nixon to turn over the tapes. Just days later, facing certain impeachment, Richard Nixon resigned from office. The case established that executive privilege is real, but it is not a shield against criminal justice. Now let's talk about the president's power of the pen. When a president wants to make policy but can't get a bill through a divided or hostile Congress, they often turn to executive orders. These are directives that have the force of law but don't require congressional approval. But this power isn't unlimited. An executive order has to be based on authority given to the president by the Constitution or by a law passed by Congress. We already saw what happens when a president goes too far with the Youngstown case. The court has struck down executive orders when it finds the president is basically trying to write his own laws. In recent years, challenges to executive orders have become routine. For example, during the Trump administration, courts frequently issued nationwide injunctions. blocking controversial orders on everything from immigration to the environment. This led to its own legal battle, and in 2025, the Supreme Court ruled in a case called Trump versus Casa that lower courts should not issue these sweeping nationwide injunctions, a decision that makes it harder to block a president's policies on a national scale. Closely related to this is the rise of what's called the administrative state. Over the last century, Congress has created a vast network of federal agencies, the EPA, the SEC, the FDA, and has given them the power to create detailed regulations that affect nearly every aspect of American life. For a long time, courts followed a principle called the Chevron Doctrine, established in 1984. This doctrine said that if a law was ambiguous, courts should defer to the expert agency's reasonable interpretation. This gave the executive branch enormous power to shape policy through regulation. But that era is over. In 2022, in West Virginia versus EPA, the court said that for major questions with huge economic and political significance, an agency needs crystal clear authorization from Congress. Then, in 2025, in Loper Bright Enterprises versus Raimondo, the court went a step further and explicitly overturned the Chevron Doctrine. The majority said that it's the job of the courts, not agencies, to say what the law is, a direct echo of Marbury versus Madison. This is a massive shift, a reassertion of judicial power that makes it much harder for a president to enact sweeping changes without Congress' explicit blessing. Finally, we come to one of the president's most fundamental powers, the ability to shape the government by deciding who runs it. Article 2 of the Constitution gives the president the power to appoint ambassadors, judges, and other officers, but they need the advice and consent of the Senate. Just as important is the power to remove those officials. But can a president fire anyone he wants? The court's answer has been, it depends. In 1926, in Myers versus United States, the court said the president had a broad, unrestricted power to fire purely executive officials. But just a few years later, in Humphrey's Executor, the court changed its tune. It ruled that for officials in independent, quasi-judicial agencies like the Federal Trade Commission, Congress could set limits on the president's removal power, such as only allowing them to be fired for cause. For decades, this distinction held. But recently, the court has started to swing back, giving the president more control. In a 2020 case, Sela Law, the court struck down a law that protected the single director of the Consumer Financial Protection Bureau from being fired at will, arguing that such a structure unconstitutionally limited presidential power. Recent decisions suggest the current court is very inclined to give the president near total control over the executive branch he is supposed to manage. The relationship between the Supreme Court and the president is a constitutional conversation that has been going on since the founding of the Republic. It's a story of landmark cases like Youngstown and U.S. versus Nixon that serve as powerful reminders that a president's power, while immense, is not absolute. They are bound by the rule of law. And yet, the debate is far from over. The modern presidency, with its vast power and global influence, constantly tests the old checks and balances. The irony is that the presidents we often call great are the ones who pushed the boundaries of their power the most. The Supreme Court's recent decisions, overturning Chevron, limiting injunctions, expanding removal power, show a court that is actively recalibrating this balance of power once again. This enduring tension isn't a flaw in the system, it's the system working as intended. It's proof of the framers' genius in creating a government where, as James Madison put it, ambition must be made to counteract ambition. This dialogue between the court and the president is a vital, necessary, and never-ending process that ensures the incredible power of the presidency remains tied to the enduring principles of the Constitution. Thanks for tuning in to G Fun Facts Online.